Judge Engoron claiming absolute immunity with his law clerk. We know her as Allison Greenfield. We call her GF here, short for her last name, Greenfield, and maybe the judge's feelings for her, we don't know. But the judge, as you can see, is sitting right next to her, and she has been the subject of a lot of concern throughout this entire trial, largely because she's passing notes after every objection. Trump's defense team, Alina Abba and others, are saying, why do you keep whispering? And the judge gagged Trump's defense from commenting on it, okay? Why are you talking to her, Judge? You're the judge, not her. And she said, you can't talk to me about that. Don't even file a motion. And when they said, we're going to file a motion, the judge screamed and scolded at the defense and said, don't do it, Chris. And I go, what the heck's going on over here? So then Trump, of course, filed a motion for a mistrial. And we talked about that. We did a full review on it. We're going to go through just very briefly for context what was in there. But then we're going to take a look at judge's order because he's denying the motion for a mistrial. He's like, no, we're not going to do that. Obviously, I have total absolute discretion with my GF. And we know that previously he said that he's entitled to have professional interchanges with her, whatever that means. So we're going to talk about it today, and then we're going to see what's happening in trial because Adam Klasfeld was there in New York after this ruling came out. We'll see what is inside of all of it. But just as a reminder, this is what the original mistrial motion looked like. In fact, it is loaded up right here. And there was some good stuff inside. We redlined this whole thing pretty clearly when we covered this in a prior segment. But just for context, okay, this is Trump saying that there is some serious misconduct here in this case, Judge. And he gave us a bunch of stuff that we redlined here, saying that all of this is really emanating from the judge's bias and that a mistrial is completely appropriate. First, Judge Engoron was including some very interesting links to articles to CNN, Washington Post, and other entities like NPR, Above the Law, and he was putting these articles in his newsletter that he was sending out to his Wheatley alumni organization. And in fact, some of those emails had what he called bonus torso photos, which had, unfortunately, a picture of the judge's bare chest. Now, we also analyzed this. Okay, this is in Trump's mistrial motion, which we covered fully, but you can see this close proximity between the two of these little lovebirds here. It's like, what's going on over there? Why are you talking like this the entire trial? And what happened was when the cameras were on them in the courtroom, they turned the cameras so that nobody could see what they were actually doing with their hands, you know, under the desk. And we're going, oh gosh, keep your hands above the table, okay? Look, you two, we don't know what you're doing under there. So they turned the cameras. All right, now this is all in this motion. And of course, there's some improprieties that people have there. We also know that the gag orders are clearly a violation of Trump's First Amendment rights, but we also know that there was considerable tension in the courtroom and that there was an opportunity where Chris, Trump's defense, said, we're going to move for a mistrial, Your Honor. We're witnessing misbehavior from you, and we are Trump's defense team. We have an obligation to raise an objection on behalf of our client. Otherwise, we're going to get in trouble. And when Chris said that, the judge scolded him and said, don't file that motion, Chris. I love her. And they said, is that out of control? Now, also, this is very important stuff that I wanted to make sure we hit. Okay, this is Allison Greenfield's dono forms. $200 to Freedom Democratic Clubs, $175 to Chelsea Reform Democrat Club, $350 to the West Side Democrats. Judge Engoron is going to cope his way through this. He's like, well, and he's going to explain it like all of these are deductible and it's not consequential. So here, $210, this one here. Okay, it turns out thousands of dollars, all right, over $3,000, over $3,900, I think, between the 2 years, and it's a lot of money. Now, part of the problem here is she was making these donos while the action was pending, And some of these donos, right, Trump is being prosecuted by Letish and Tishy James in New York. And these groups were actively supporting the Attorney General. Okay, so the law clerk who's going to be hearing the case against Trump is making donos to support Tishy Letish in New York. She was also attending political gatherings, engaging in partisan activity, and so on. We read through the whole thing, and so I don't want to belabor it here. Please watch that video if you missed it, because this thing is just a mess, all right? The amount of corruption and disgusting behavior inside this is bad. But the judge is going to cope his way through it. He's going to say, well, you know, it's all basically within my discretion, and you don't get a mistrial. And so this was previously filed by Alina Abba and, of course, Clifford S. Robert, who submitted an affidavit previously saying, Judge, I've been here. I've been practicing law for a long time. I've never seen anything quite like this. And so we, of course, are going to go into this because Engoron denies the motion for a mistrial. We'll get right into it. But first, a quick message from our friends and sponsors of this show. Cereal is one of my favorite meals. It's fast, easy, requires almost zero prep, uses only one utensil, and it's very easy to clean up. It's basically perfect. But the problem I found with my morning breakfast routine is that many of the cereals I was eating are packed with sugars, but not the cereal from Magic Spoon, the sponsor of this video. This cereal is not just delicious, it's fueling my day with 13 to 14 grams of protein and only 4 to 5 grams of net carbs per serving. They have flavors like fruity, frosted, cocoa, peanut butter, all with the magic spoon flair that brings back that childlike nostalgia. It's perfect for anyone who's into a keto-friendly, gluten-free, or just a conscious eating lifestyle, and it's also got zero sugar, as in zero. It has the taste I enjoy, but it feels so much better knowing it's made with only high-quality ingredients, and I'm getting a little extra protein in my mornings. And because you're part of the Watcher family, we've got a special treat just for you. Use code Robert to get $5 off any order. Simply click the link below or go to magicspoon.com/Robert to place your order, or scan this QR code right here on the screen to get your magic spoon with the discount linked inside. So whether you're looking for a premium breakfast that keeps you full, or you're on a diet like keto, or just cutting back on sugar, Magic Spoon fits the bill. I've been enjoying my morning cereal so much more since I found Magic Spoon. It's the perfect start to my day, and when you try it, I think you'll feel the same. And they have a 100% happiness guarantee on your order, because Magic Spoon is here to make your morning great. Don't forget to use my code Robert for $5 off at magicspoon.com/Robert, and I can't wait to hear which flavor becomes your favorite. And now we're back. Engoron denies the Trump motion for a mistrial. We're not surprised about it at all. We're going to go through it in detail, and then we're going to see what happened in the trial after we read through this motion, because trial's back in session. Engoron is just marching forward. Letitia and the rest of the people there on behalf of her just prosecuting ahead. And so here is what we see filed out of the Supreme Court of the state of New York, County of New York. The case, of course, is Tishy Letish and the people versus Donald Trump and everybody else's entire extended family. So this is President Engoron, right? And he's asking himself whether I'm going to be granting this order to show cause. And this was a vessel. This was the mechanism by which the defense was asking for permission, essentially, to the court to make their complaint. They said, Judge, how do you want us to address your weird footsie games and your love notes with your court clerk? Just let us know. And he said, well, how about an order to show cause might be the right way to do it? And they said, all right, we'll file it. So here's what it looks like. And here's the judge's order on that. And they were saying motion for a mistrial. We need a new trial, right? This whole thing is so bad that we got to do it over again. So the judge says, all right, you whiny Trump lawyers. Says, upon reading and filing the affirmation, this is what Robert submitted, and also reading the affirmation of David Demarest, and also the memorandum of law that we read through previously here, and upon all the pleadings and proceedings, and sufficient cause having been shown. Okay, so this is an order, that is not going to be signed. All right, so the judge is declining to sign this for the reasons stated in the order annexed here too. So I'm not going to sign this. He's saying, let the people of the state of New York, through Letitia James, show cause before this court on why an order should not be made and entered granting a mistrial. Okay, so they're basically submitting to the judge a blank order, right? Hey, submit it as an order to show cause is kind of when, in Arizona, the way we use it is kind of like you're in trouble. The court is asking you to come up and do something, like your case is problematic, other side respond. And that's what they're asking here. So Tish, they say there's a motion for a mistrial. The judge wants to hear arguments on this. You need to show up and explain why there should not be a mistrial under the law, and granting such other relief that seems appropriate. Ordered that opposition papers are served and all the things, right? The judge could have set dates on this. Could have said, okay, this would be on the 27th day. This could be on the 31st day. And then the judge is making a little correction here. He's inserting that. He says, by e-filing the same on this day, let's say, the 30th and whatever. But the judge is saying, I'm not going to sign this order, right? I know Trump's defense, you want me to, like this is the prospective order, but I'm not going to sign it, and here's why. I am not going to be granting a mistrial signed off here by Judge Arthur the Engoron. This is his order, declining to sign. Judge Engoron declines to sign Donald Trump's proposed order to show cause for a mistrial. The judge writes, he says, this court declines to sign Donald Trump's proposed order to show cause, seeking permission to move for a mistrial. Now, they say the law provides that at any time during the trial, the court, on motion of any party, may order a continuance or a new trial in the interest of justice on such terms as may be just. And Trump and his supporting papers, they argue that a mistrial is necessary because essentially the court has exhibited bias. Judge Engoron. He says, 1, directly bias, as I publish a high school alumni newsletter with links to articles referencing this case, which he did. And we read through those articles here on a prior video. And on this channel, we have our videos organized into case playlists. So if you haven't seen anything or you're missing something on the New York trial, go to the homepage. You'll see the playlist there for New York. You'll see all the New York videos there. Same for the other cases. So we talked about this. We actually went through the newsletter with the bonus torso photos and the links. And he was saying, man from class class of 1932 or whatever. And he said that I am prosecuting Trump. Yay, look at me. So directly through the newsletter and indirectly through my principal law clerk, known as Allison Greenfield. Really the star of this whole show these days. Like, she's like the main crux of this case now. Allison Greenfield, the judge's GF, whom they allege violated New York law by exceeding the permissible amount of political donations in a calendar year. And we saw that there's a lot of donos that she made. We saw the whole spreadsheet of them. The judge says, well, as an initial matter, to the extent that Trump's arguments rely on alleged, quote, facts, the judge says in parentheses, facts, in quotations, says based upon editorial opinions that denounce plaintiff's case, such opinions are irrelevant and of no evidentiary value. So they say that Trump's facts are just, quote, facts. They're not really things. They're based on editorial opinions and they denounce Tishy's case. And so they're irrelevant and they have no evidentiary value, which is nice that a judge can just say that. So they say equally irrelevant is the, quote, expert affirmation of yet another retired judge. And so what happened was, in these affirmations that we read through previously, they were saying, Your Honor, I've been practicing for a long time, never seen anything like this. The judge sits on the top of the bench, the witness sits below because the witness is below, and then everybody else sits below that, right? And the jurors are down here and the clerk's over here, and like the judge is of the highest level for a reason. I've never seen anything like that. Just one example of some of things they haven't seen. And so they brought them in and they read them in. The lawyers read them, judges read them. Never seen anything like this, Judge. So he says, oh, another retired judge who's not even on the bench anymore. His name is David, says Engoron, who states that he was, quote, retained as an expert by Trump's counsel to opine on the legal basis for a mistrial. He says, I don't care about this guy, in quotes, as I explained in my September 26, 2023 decision, granting partial summary judgment, legal arguments are for counsel to make and for judges to decide. And therefore, says Engoron, such an expert affidavit is neither necessary nor permitted. I'm not even going to read it. The rule from prohibiting experts from providing their legal opinions or conclusions, quote, is so well established that it's often deemed a basic premise or assumption of evidence law, a kind of axiomatic principle. And he cites another thing, says precluding expert affidavits on the law. He says it remains black letter law that expert legal testimony is not permissible. Expert legal testimony is not permissible. Okay, so what they're saying is you can't bring in an expert on the law. I am the law, says the judge. I decide what's going on in my courtroom, and you can't criticize me for your interpretation of the law. Honestly, what the Court of Appeals is for, right? That's Court of Appeals can come in and then reverse that. So a bunch of experts aren't going to come in here and dictate to a judge how this goes, which of course is true. Like, that is how it works. But they're trying to make the point to the judge to give them permission to even move forward with the motion for a mistrial and submit this and have Tishy respond and have arguments on it and the whole thing. So he's just saying you can't, I would say this, as persuasive authority, not mandatory authority that they have to follow. So it's not precedent, right? It's not precedential that they have to follow it. It's just, hey, judge, by the way, other experts who watched a lot of trials, they also say you're out of control. So they say this court has already cautioned Trump's lawyers against submitting, quote, expert opinions on purely legal issues. He's like, don't question me. I already know what I'm doing. How dare you? Moreover, as detailed herein, former Judge Demarest, David, he says, his expert opinion, this retired judge, it incorrectly summarizes the relevant law, idiot, and fails to address all the applicable governing ethical guidelines. So the judge says, I'm way smarter than him, and I'm still a judge, and I have a principal law clerk, does he? Now he says, Trump correctly asserts, now we're getting into the thousands of dollars of donos that she made. They say Trump correctly asserts that the New York Code generally limits to $500 the political contributions that members of a judge's staff may make annually. $500. Now we already saw that previously, right? The dono amount is pretty significant, kind of a lot more than that. As we saw here in the original filing, there's a whole spreadsheet of these things, and the spreadsheets have a lot more than $500. You saw this one right here, $250, $250. There's $500 between these two right here, and these went to the same organization. Look at that. First one we looked at, $250 on 6/1, another $250 on 6/1/2022. Allison Greenfield made two donos, $500 total to Jim Ola's Liberal Democrat Club, right there. And another $100 to Sivin, another $100. Sivin. New York County, 25, those are smaller amounts. $100 here, $250 here. Jim Oles, okay, so boom, Jim Oles has $750 right there, right? We've already got that one, just taking a quick look at that. So he's $750, three donos right there to Jim Oles. Now there might be even more. So she's already with one person broken through the $500 barrier to one recipient. Now it's much more than than that, right? It's not only one recipient, but 200 here, 175 here, 350 here, 50, 50, 50. In aggregate, it's $3,900. So let's see what the judge does to get rid of this one. He says, yeah, it's true. It generally limits the political contributions to $500 that they may make annually. So let's see what the judge does with this. But they say, it looks like total, okay? $500 total, not per person. It's not like you can get 500 to candidate A, B, and C. No, 500 total. You either give it to all to one or, you split it between the three of them. But they say, okay, yeah, the judge is like, yeah, it's true. Trump is right about that. However, says the judge, Trump and their, quote, legal expert, in quotes, they fail to cite the applicable unambiguous ethical guidelines for, quote, candidates for judicial office. So she was running for office at the time. So that is found in Judicial Ethics Opinion 9819 footnote 1, which is just hysterical, okay? So now he's referencing to a judicial opinion, which is an opinion interpreting the rule says this, it's $500, right? So facially, it's clear, but he's going and finding some other thing. He says, since 2020, my principal law clerk has been pursuing elected judicial office. Wow. So that means you can just pursue elected office for years and lose and just do whatever you want, is skirt the rules, break the rules? That's nice, Judge. It looks like it's a little bit of maybe an escape hatch in the law. Says here, my principal law clerk since 2020 has been pursuing elected judicial office. And as the governing ethical guidelines for the law contemplate and expressly permit, indeed, as the judicial opinion clearly states, the $500 limitation on political contributions does not apply to an appointee's contributions to his or her own campaign. What? Nor would there be such a monetary restriction on the purchasing of tickets to political functions. Okay. Well, she made that dono to Jim and Chelsea Reformed Democrat Club, and New Yorkers for Alex Boris, and other people, Tom Sylvan and others. Jim Oles, Liberal Democrat Club. That doesn't sound like it's going to her. Let's see where the judge goes. Says, now when deducting the price of tickets to political functions that my law clerk attended from all the contributions to which the defendants cite, that whole list there, the remainder is still well below the ethical and legal permissible annual limit. What on earth did he just say? So, do you have receipts for that, Judge? Do you have a spreadsheet to show us the receipts on that? He says, when deducting the price of tickets to political functions, so he is trying so hard to make this fit, it's embarrassing. It's actually embarrassing. This is like an F in law school. You fail. Okay, nice try. But you fail. So you're saying, wait a minute, what? That she bought tickets to political functions, the price of the tickets to the political functions that my principal law clerk attended, from all the contributions to which they cite, the remainder is still well below the legal and permissible annual limit. She says Trump further attempts to argue that since my principal law clerk attended events sponsored by certain organizations, also legally and ethically permitted, each and every separate action and position of those organizations should be imputed to her and by proxy to me. Well, that's what the rules say. It says members of a judge's staff. Yeah, so it's you. You're the judge, I think, unless she is. We don't really know. They say such arguments are nonsensical. Would you like to explain some more? In any event, they are red herrings, as my principal law clerk does not make rulings or issue orders. I do, says the judge. It is just wild. So he says, I'm not even going to address these arguments. Now, again, I'd like to know what he's specifically talking about, okay? We have a spreadsheet here that shows what these donos are. So she made money to political organizations, and I guess those were like tickets. Those were like tickets to those events, and she's allowed to buy tickets to events. So she makes a $250 dono. Let's just go back to Jim Oles. $250 right here, $250 right here, and $250 down here to Jim Oles. Right there again, $250. So we've got receipts for that. So that is over $500. So she went to, I guess, 3 different events for him. And what did those tickets cost? I don't know what they cost. Like there should be a dollar amount, right, from Jim, because she put $750 to that guy. And I don't know what the tickets costs, but that's how she is being allowed to deduct it. Okay, she's allowed to purchase tickets, go to political functions, and it was just like carbon credits, it got offset. So she's allowed to deduce it. It all evens out. Now, if the judge says that, I'm fine, but can we see the receipts for it? Like, do we have a ledger? Can he put that all down on the books for us? But he won't do that. The remainder is still well below the legal permissible annual limit. So if she spent $3 grand, it was $2,500 in tickets. Incredible. But he's not going to deal with it. Not going to really, he says they're just nonsensical. And they teach you this really in any writing, right? Anytime somebody just says like, clearly this is true. Well, you have to explain it. It's not clear. Like, you need to tell us. Such arguments are nonsensical. Well, why don't you explain it? He doesn't. He just says, and in any event, they're a red herring because I make the rulings. Okay, well, is your law clerk still in violation of the law or not? I've explained on the open record, I have pursuant, oh, here he goes, man. He's getting into it now. I have pursuant to the law and advisory opinion from New York, an absolute unfettered right to consult with my law clerks, oh, gross, in any way, shape, or form that I choose. Ugh. Gross. He says a judge may consult with court personnel whose function is to aid the judge in the carrying out of the judge's adjudicative responsibilities or with other judges. Unfettered, absolute, unfettered right to consult with my law clerk in any way, shape, or form I choose. Even if that includes love notes, even if that includes playing footsie. We don't even know if she's giving him massages or whatever. Her laptop is right there. She's literally co-judging the case with him. He's consulting with her repeatedly throughout the trial. Like, I joke about some of the more, jokey things, but seriously, like, why are there two judges up there? It's not a joke. The judge should be able to handle this on his own or not. And as Alina and Trump's defense have said, they are watching the judge change his opinions mid-opinion. They'll listen to the objection. The judge will say, that sounds pretty good, until she gives him the side eye and says, you're sleeping on the couch tonight, buddy, if you do that. Okay, sorry, sweetheart. So then he makes a change and they say, enough already. And if the judge wasn't doing anything wrong, why is he screaming at Mr. Keese about this? Why are they moving the cameras around so that you can't see what they're doing, so the press can't see it? Because he knows, right? And he's panicked about this. And I think he's digging the hole deeper, okay? Every single time he writes an opinion like this, it seems more and more ridiculous. Like, even the Court of Appeals is going to go, bro, can you just stop talking, please? Like, let them talk about your law clerk. Just let them talk about it. What are you so freaked out about? Just stop playing footsie with her. So the judge says, all right, however, as I have made clear over the course of this trial, my rulings are mine and mine alone. There is absolutely no co-judging at play. Move her out from under you and stop taking her notes. That I may consult on the trial record, the law, and the facts before issuing any respective ruling is within my absolute discretion, and is in no way evidence that the final decisions are anyone's but mine. Accordingly, there is no factual or legal basis for a mistrial based on the allegations against my principal law clerk, my GF, my Greenfield. To the extent that Trump argues that I've exhibited bias by stating in court when he said this, I'm not here to hear what Donald Trump has to say. When he said that, Trump was on the stand, Trump was talking, and he said, shut your mouth. I'm not here to hear what Trump has to say. We're all looking at each other like, he's on the bench in a courtroom, judge. You just swore him in. Now, such argument is disingenuous, says the judge, and it's made in bad faith, as defendants omitted what I said immediately after that sentence, which is, I'm here to hear him answer the questions. And he says, indeed, those are precisely the roles of the witness and the finder of fact. Well, yeah, judge, but first of all, you caught yourself on the second half of that statement there. And the point is, you want him to answer questions the way you want him to answer them, okay? It is not the judge's role to rein in a witness. It is the government's role. And the judge kept screaming at Trump, and we went through the transcripts here, the excerpts that were posted, and we listened to them. And the government was even saying, hey, we're fine with Trump just rambling off. Let him go, because they're transcribing everything, and they're going to give it over to Jack Smith and to everybody else. They love it. He's under oath on the record. Let him go. And the judge was cutting him off. I don't want to listen to this guy. What, judge? Mind your business. The government's okay with these questions. Talk to your clerk. Sheesh. So he is now saying, I'm not here to hear him. You go, what? Okay, well, obviously that's true. We know you're here to convict him and to abuse him and the rest of everybody in his orbit. So he says, now I am precisely, that's what I'm supposed to do, is to hear him answer questions. Well, the government was okay with his responses and you weren't. So they say here, Engoron continues, and Trump also takes issue with my publishing of my high school alumni association areola newsletter, alleging that it was inappropriate to include links to articles referencing this case as it it creates an appearance of impropriety. And of course it does. The judge was highlighting is like man from, 1847 is in here. And then he would post, link, and all the links were bad for Trump. Judge orders this. Judge rejects Trump request. Judge orders summary. Blah. And he had a bonus torso photo in there that has, haunted a lot of people's nightmares on that email list. They're like, oh, just happening. What's going on? It's gonna be a busy day at work today. Oh, I wonder what's going on at Wheatley High School. Oh yeah, that's nice. I remember her, Barbara. She was very sweet. Oh, what's happening? Oh my gosh, what are these? And then they run into the garage and dump bleach in their eyes. So he says, in 2007, this is Judge Engoron, I co-founded the Wheatley School Alumni Association, which we unfortunately read through, and began publishing the association newsletter. All issues are free of charge and reach approximately 4,700 email addresses containing no advertising. So boom, bonus torso photo right in your face, almost 5,000 people. Now they contain news about the school, its faculty, and primarily its graduates. When an online publication mentions a graduate, including myself, I include an excerpt or a link, or usually both. And consequently, I have been the subject of entries concerning this case due to its undeniable newsworthiness. Which you're gagging Trump over. You understand that? Of course it's newsworthy, so Trump should be able to talk about it, and you're not letting him. So in fact, Judge Engoron says, because of my job, I, the editor, have been subject of a fair amount of news coverage over approximately the past decade. However, I neither wrote nor contributed to any of the articles on which Trump focuses, and no reasonable reader could possibly think otherwise. No, but you are the editor of it, and you're including them all, and you're selecting the articles that seemingly have a particular bend to them. They're all in favor of you and not Trump. So you're not linking Breitbart, for example, Judge, are you? Saying that psycho judge is wrecking American democracy and ruining business in New York. Did you link to that one, Judge? No, you didn't. Many years ago, a legal ethics lecturer told a group of jurists, oh, this is great. Judge is giving us an anecdote here in a legal order. Great. Thanks for your anecdote, Judge. Are you going to footnote this at all? No. He says here, of course not, because everything's a red herring and he's not addressing anything. Honestly, I think he just types this probably when he takes a sleeping pill late at night. So many years ago, a legal ethics lecturer told a group of jurists, of which I was one, that, quote, judges do not lose their individual identities or personalities just because they are judges. Wow, it's brilliant. A significant part of my personality and identity, oh gosh, here we go, he's going to identify, is as a graduate of an institution. Well, that's, actually quite normal, that I admire. Okay, let's see where this goes. Who has taken, this could go a lot of different directions when we talk about identity. Who has taken on the time-consuming but gratifying task of keeping its alumni connected and informed about many topics, including his chest and his progress at the gym. Now, none of this has anything to do with, much less does it interfere with my presiding fairly, impartially, or professionally over the instant dispute, which I have now been doing for more than 3 years and which I intend to do until its conclusion. Well, no, Judge, it shows that you're biased, okay? It shows you've got a conflict of interest. Not only are you biased, but maybe you're getting some self-gratification out of this whole thing, okay? In many ways, more ways than one, to 5,000 people. Is there an unsubscribe button on that thing? Plaintiff has advocated for a full briefing schedule, emphasizing that although it believes Trump's motion is without merit, it believes briefing would economize the timing and the effects of any appeal. So even Tishy is like, hey, can we please respond to this? But the judge says, no, you can't. In good conscience, I cannot sign a proposed order to show cause that is utterly without merit, and upon which subsequent briefing would therefore be futile. So you're gagged from even, briefing. Sorry, Tish, you're not even briefing. The court has considered Trump's remaining arguments, including but not limited to Trump's assertions that the court's evidentiary rulings are per se evidence of bias, as they allege there are more rulings in favor of the government than of the defense, and they find them to be similarly without merit or dispositive. Now, I stand by each and every ruling, and they speak for themselves. And finally, the judge says, as I have made abundantly clear, the basis for overruling objections to allegedly time-barred evidence is legally sound, as there are statute of limitations on claims, but not evidence. Accordingly, the court hereby declines to sign Trump's proposed order to show cause to get permission to move for a mistrial. Signed by the areola judge himself, Arthur F. Engoron. And do you feel satisfied? Did he respond to any of Trump's points in there other than very topically, very, very briefly? We don't even have receipts for the donos. I'd like to see the receipts, Judge. Get your law clerk to show us the donos receipts that she made, because this is just about what you'd expect. So Trump, I'm sure, will be appealing these orders, and there will be a lot more to follow. Now, trial continued on in the day, and Engoron listened to more evidence from Donald Trump's defense. And to see what happened and what took place there, let's tune in and check out what Adam Klasfeld is reporting on. Of course, Adam Klasfeld reports over for The Messenger. A great follow if you're interested in this stuff. You can follow him at Klasfeld Reports on the X platform and elsewhere. And here's what he says. We got a new witness who is on the stand in week 8, I believe, of trial. Now, the early part of testimony obviously involves your capabilities, your qualifications, your credentials. But here, Mr. Miller is back up on the stand. Now, he's got 2 decades, is this witness. 2 decades, Mr. Miller, of experience in insurance. Tishy tried to block him. His name is David, and he is Trump's witness. They say that he's got 2 decades of experience. He's the owner of an insurance agency called David Miller Insurance. And we got another big witness coming in later. I'm gonna ask him some questions. Miller, I want to ask you about this internal report here. You recognize it? That looks familiar. It says here that this was about a decision to underwrite the Trump organization. You recognize it? Yeah. And this report says that Trump had a personal net worth of about $3.2 billion. Does that look right? He says, well, yeah, that's what it says. Where did this come from? He said, I don't know, underwriters, they often will rely on media reports. It's a pretty common thing. Journos are reporting on things and look at those numbers. Is that common? Yeah, happens all the time. Now, okay, no further questions. Thanks, Judge. Sometimes the media gets involved in valuations. Got it. Government comes up. This prosecutor is named Andrew Ammer. He begins cross-examination. He says, okay, David Miller, now you testified earlier that Zurich likely didn't inspect Trump's finances too closely. Didn't you remember you said that? He said, yeah. And you said that that might be a major deal, a favor to a major broker, somebody called Aon. Is that true? Yeah. Are you saying that the broker would have cut off business with the country's largest insurer? And Miller says, no, that wouldn't happen. Mr. Miller, are you being paid to be here today? He says, yeah, I'm an expert witness. I get paid money. How much? $350 an hour. Well, how much do you work? He says, I don't know, between 45 to 50 hours, before when I do an analysis on this. And so he's doing the math. Oh, so 350 times 50 hours, that's a lot of money, isn't it? Do the math at home for you math people. Now, Klasfeld continues. Mr. Miller, I want to ask you about Trump Organization. Now, since the Trump Organization was privately held, you'd agree that banks and insurers had no way to obtain documents that they did not get from public records? And he says, yeah, generally that's true. And you would agree with me, with the state's position, that the Trump Organization failed to disclose litigation or inquiries that could lead to a claim, right? So Trump had documents that were non-public, and he didn't disclose the litigation of those non-public documents to other people who might have wanted to know about that. Would you agree? And he says, yeah, I think I would. Yeah, a state's witness, an underwriter, he said it's standard fare to check for that. Would you agree with that? And Miller says, yeah, I'd agree with that. It's standard practice to check for that. All right, we're still going through some valuation stuff, and kind of a short thread there, but Klasfeld is reporting from the afternoon session, and we'll see what else we've got. It begins, we've got another witness up on the stand. And again, Klasfeld's reporting, he's saying, Jeff McConney, now seated at the defense table after lunch. The defense case is now going to be bringing in this guy, Jeff, to talk about the fraud evidence. And they call him up to the stand. Mr. McConney, promise to tell the truth, how God? I do. Tell me about your background. Tell me about your experience. Well, he says, I began working on Trump's father's real estate business in Brooklyn, working with Papa Trump, Fred Trump in Brooklyn. Started working with him, worked my way up the ladder. And you did that for a long time? Yeah, a long time. Great family? Yeah, great company. So the Trump team, Jesus Suarez, who's up, the defense lawyer, he asks McConney, thank you, McConney. I want to ask you about the accountant for the Trump Organization, Donald Bender. You know who that is? Oh, yeah, of course. Don, great guy. Actually, not a great guy. Yeah, Don, he's an idiot. We've been trying to blame him for the discrepancies. Oh, that guy? Yeah, moron. He says, well, the accountants in these cases, they have carte blanche to anyone at Trump Organization. They can just go around and get information from anybody. He says, Bender? Oh, Don, that guy? Yeah, he could walk in and talk to anyone he wanted. It's not a structured company like IBM. He's like, I'd never work for an IBM. Like, we don't have like a CFO guy and all this, multiple layers. I fill out a form, get on the account. No, Don just walking around and asking people info. Trump's defense says, did anybody try to hide anything from Don Bender? Maybe try to hide litigation? No. He says no, that he didn't. And they take a break. Afternoon break. Judge says 10-minute break. See you in 15 minutes. We're like, oh gosh, Judge, come up with a new joke. And we're back. McConney's back on the stand. He says, Trump's defense, Mr. McConney, I want to ask you about some different Trump properties. You're familiar with Trump Park Avenue? Yeah. And you're familiar with Lenox Hill? Yeah. And that's the one that used to be the historic Delmonico Hotel? He says, yeah. The Trump family lived there? He says, yeah, Ivanka Trump once had a penthouse there, and they had options to buy a couple of units, and those units were well below market value, says AG, right? And McConney, he says, you remember the spreadsheet that we talked about, or you saw previously? Yeah. This one's related to the valuation of Trump Park Avenue. Is that true? He says, yeah. Now, walk me through how you came up with these numbers. He says, well, valuation is based on the anticipated selling price of unsold residential units and the selling price. And the judge finds that Trump Organization ignored the rent-stabilized units. Now, Trump's defense says, okay, Mr. McConney, I want to introduce an email to you from you, Jeff McConney, to Donald Bender, and one other person from March 12, 2021. Do you remember this, Mr. McConney? He says, yeah, I remember. It says in part, Trump Park Avenue, January 2020. You see that? Yeah. It says unregulated total was 179,219 on my filing, 17,000 for the regulated. Does that look right? Yeah, I recognize that. And so Mr. McConney, says Trump's lawyer, Jesus. Now the email, it seems to show that Bender knew about the above discrepancy between the rent stabilized units. Does that look right? He says, I see that. Is that what he calls an inconvenient fact? That's kind of an inconvenient fact for the state, isn't it? He says, yeah. So in other words, Bender knew that there was a pretty big discrepancy. And he says, yeah, it's not convenient for them. Now I want to also introduce a document about the valuation of rent stabilized units for different properties, right? If they didn't do it this way in this property, let me show you how they did it in other properties. Government objects. Objection, Your Honor, this is totally irrelevant. Their objection's ridiculous. They argue about this. AG's counsel calls for the witnesses to leave the room. Your Honor, can we excuse the witness, please, while we get into this with you? Engoron says they should excuse the witness and argue. Yeah, let's get rid of them and then we can argue about this. The witness leaves the courtroom and Engoron says, yeah, I don't think it's really relevant, but I'm not sure. So I'm going to allow this into evidence, which is the other analysis, is the other valuation. It comes into evidence. And again, another day of valuation. So, all right. So that is Engoron's courtroom. We get a couple of additional witnesses. Of course, we also got Engoron denying Trump's motion for a mistrial, and Trump's defense, of course, will be appealing this and many more things. We'll be continuing to cover this and all of the other Trump trials, my friends. So thank you for subscribing. Thank you for checking out robertgovea.com. Now, if you want to get any of these PDFs, they'll be on robertgovea.com along with a report that synthesizes this entire segment. You can sign up for our daily newsletter, get access to all this stuff. We don't want you to miss a thing, and we'll look forward to seeing you on the next one.